Well, I guess Facebook's not. There it goes. Okay. I wasn't sure if it was going to cooperate. So I do not have a ton of time to do this update, so hopefully you guys don't have a ton of questions for me today. But I will do my best. Started trying to do this update, I don't know, 2 hours ago, and it's been one of those days. So inundated with calls and texts and emails. But in the meantime, I have continued to receive emails from different things being filed with the e-filing system and whatnot with the Michigan Supreme Court. So all in all, having to wait a little bit to get these get this update out wasn't actually a bad thing, because then I can give you an all-inclusive update about the other things that have continued to be filed today since I originally started trying to get things going. The first two documents that I was originally going to do the update on are already updated to my website. They're in the description of this posting, so those are available for your viewing. I'm not going to update every single document to my own website, the restorefreedomkh.com website that I'm going to be talking about. A lot of them are not, well, these ones I believe might be put on the Michigan Supreme Court's homepage, at least temporarily, for all the public to see, but I'm not quite sure. I know that in general, there are documents on both of those cases that are listed right at the bottom of if you go to the Michigan Supreme Court's homepage, scroll all the way to the bottom, there are documents posted there as PDFs that you can view from either of these two cases that I'll be talking about. I guess real quick, I already have questions and comments. So you are welcome. Lori, I love you too. Lulu, yes. You are welcome. Other Lori, yes. I do feel a little bit better. We have some positive things that are working. And quite frankly, I was, feeling really bad about not being able to help some people that have been calling me. And well, I've had more people today that I haven't been able to help. But I was able to help someone with two huge needs because of the video I did yesterday on prayer. I was able to have somebody who heard about that and has connections in a different part of the state that was able to find a way for the woman who needed some medical care and some physical therapy for her to be able to get that care potentially. So finding places that were not going to turn her away because she wasn't wearing a mask. So it was a needed thing, right? God works in mysterious ways. So, all right. Yes, I do feel better, but having many people involved in helping with things obviously always helps things too. So right down to the situation here. Actually, I don't know if I said this. For those of you who might be brand new, because we always have a few people that are commenting on that I noticed later, had no idea who I was, and I just assume everybody who's watching my videos knows who I am at this point. But if you don't, and you can't read the signs behind me or the certificates behind me, I am attorney Catherine Henry, constitutional attorney. I have my own law firm, and I originally had it named as Catherine Henry PC when this all began. But I also, throughout this process of trying to fight in the craziness and the unconstitutional actions of our government related to COVID-19, I started the Restore Freedom Initiative Constitutional Amendment Petition. And so we still need signatures. If you haven't signed yet, make sure that you do. I'm sure one of my really awesome volunteers like Andrea or Lori or Lacey or my husband Mike, somebody is going to be on there giving the link anytime now if they haven't already, so that you can see go on our website, sign up to be a volunteer to help us circulate and get signatures, or to sign if you haven't signed yourself. So we'd love to have you involved in that way. And yes, it's related to this because all these cases that I'm about to talk about and the motions being made and everything else won't ever have to happen again if the constitutional amendment gets enough signatures, gets on the ballot, gets voted in November of 2022, all of this will be a moot point because it won't be a problem. Instead, the court cases that will be happening will be prosecutions of government officials who are violating the Constitution, because the huge initial layer of immunity that will happen will be gone. So, at any rate, going on to things. I'm going to save the bigger one for last. So, at 11:15 in the morning, Attorney Michael Williams, wait, let me make sure. I believe it's Michael Williams. I believe this one was submitted by Attorney Michael Williams. He filed with the Michigan Supreme Court a motion to participate in oral argument. Quite frankly, I honestly don't see in the filing system anywhere where an underlying brief had been filed. So obviously there must be one if he's filing a motion, the motion that he did today, because what the motion he did today is he's asking the court to allow him to participate in oral argument. So as of right now, it is the attorneys for the plaintiffs. This is regarding the case that is scheduled to be heard in the Michigan Supreme Court on September 9th. It used to be scheduled for September 2nd. It is now moved to September 9th. It is the only case that is scheduled at this point to be heard by the Supreme Court anytime in the next 2 weeks on any of these COVID-19 related issues. And so it is scheduled for September 9th at 9:30 a.m. And based on all the orders that have been coming out and everything else, the news releases and things like that from the Supreme Court and the emails that I have received personally, it looks like the hearing for this case that was a federal case and has 2 questions certified down to the Michigan Supreme Court to handle so that that original case can go back and be dealt with at the federal court level. It looks like that hearing, it was scheduled, like I said, for September 2nd. It is now moved to September 9th, starting at 9:30. The people involved in that are the doctor's offices. The title of the case is Midwest Institute of Health, Grand Health Partners, Wellston Medical Center, Primary Health Services, and Jeffrey Gulick. I think I'm saying that name right. So it is 1, 2, might be actually only 3. I had been saying it was 4 doctor's offices or medical offices, but it looks like it might only be 3. And then 1 patient, and that patient had been denied medical care, a surgery. I believe it was a knee surgery in the context of these COVID-19 executive orders. So at any rate, those medical offices and this patient came together as plaintiffs, filed a lawsuit against the governor, the Michigan Attorney General, and the Michigan Department of Health and Human Services Director. And so they filed in federal district court in the Western District of Michigan. In case anybody is wondering, yes, I am licensed to practice or admitted to practice in that court. But the case was filed there, and the trial court judge for that federal district court said, if I can decide this case based on state court law instead, I'll do that. So I'm going to go ahead and send these 2 questions to the Michigan Supreme Court to answer, which is what they're answering, what they're having oral argument on September 9th in order to be able to answer. Those 2 questions being, number 1, did the governor, by issuing these executive orders, violate state law, either the Emergency Management Act of 1976 or the Emergency Powers of Governor Act of 1945? Did she violate either one of those laws in issuing these executive orders after April 30th? Of course, my answer is yes, because that's how the law works. You can't cherry pick and choose which ones you want to follow. In any event, the second question is whether the Emergency Powers of Governor Act of 1945 and or the Emergency Management Act of 1976 violate the Michigan State Constitution, especially with the separation of powers or the non-delegation doctrine, right? So that the fact that, not delegation doctrine, non-delegation clause, we actually have language right in our Constitution that says you can't you can't be exercising the powers of another branch of government. It says in Article 3, Section 2 of our state constitution that we have three separate and distinct branches of government, and you, say as a executive branch member, the governor, cannot exercise powers properly belonging to another branch of government, say the legislature. So that is in our state constitution. And so the question that this federal court judge said, question number 2, was, do either one of these Emergency Management Act or Emergency Powers of Governor Act violate that separation of powers by allowing her to exercise powers properly reserved for the legislature? So I answered yes, and those 2 points have actually been things I've been arguing at the Michigan Supreme Court and Michigan Court of Appeals in my amicus briefs all along in this last few months. So I did file a brief in this case in the beginning of August, and at the time that I submitted, I believe I was only one of 3, and so I had also requested for oral argument time, which is not a usual occurrence for amicus attorneys to be able to have oral argument time. There's a lot of reasons why, but essentially the briefing, if you are allowed to have your brief accepted, then that is basically what the Supreme Court justices will look at and read to whatever extent they believe it will be useful for them in determining the outcome of the case. So there were 3 amicus attorneys that had filed their briefs, and I was named as the only one that was given some oral argument time, which would have been on September 2nd, but now they moved it to September 9th. And the last order I saw said that, or what, I don't know if it was necessarily in an order, in a communication from the court that I saw, is that it's going to be the plaintiff's attorney that will be arguing first, and they get 30 minutes of time. And then I'm given 5 minutes of time. I'm a non-party, so 5 minutes. I'm taking it. It's great. And I will be arguing second. And then the Michigan Department of Health and Human Services and the Michigan governor, the attorney representing those offices, will be going next, I believe, and then the Michigan Attorney General. The attorney representing the Michigan Attorney General's office will be going after them, I believe. At this point, I had seen 6 briefs, essentially, that had been filed for amicus briefs in the case. Had not seen one from the legislature, or I did see one from the House Democratic leader and the House Democratic caucus, but I had not seen one from the legislature as a whole. So I must be missing one, though, because what I just described to you at the beginning of this statement was that at 11:15 a.m., the legislature, by Attorney Michael Williams, had filed a motion in this case he essentially filed 2 motions. One was that he should get oral argument time, and essentially expanded oral argument time. So more than just the 5 minutes that I'm getting, essentially. And number 2, the other motion was just that they consider his request very quickly, because obviously this hearing is coming up on September 9th. And so if they decide on September 10th about it, well, then it's too late, right? So he's asking for immediate consideration of that. So with that one being filed at 11:15, at 2:08 p.m., the House Democratic leader filed a motion to participate in oral argument, and they are not asking for expanded time, I don't believe. Yes, okay, so that's kind of what I figured. Because the legislature majority caucus is seeking oral argument time to support the plaintiffs in this case, she believes that they then need to have oral argument time to balance that out And so that's why they're asking for oral argument time. So at any rate, that it is in direct response to the fact that the legislature filed a request to have oral argument time heard. Because again, despite what the Senate Majority Leader Mike Shirkey has said, or despite what the mainstream media has been saying, the case that was originally scheduled for September 2nd, now scheduled for September 9th, that case is not the legislature's lawsuit. Nothing had been filed, nothing. There was no appeal for the Supreme Court on that case. That case had just come out a week ago today is when the Court of Appeals issued their decision on that. And on that point, I had told you guys a couple weeks ago that my best guess was that the Court of Appeals was going to wait, in fact, until Friday, August 21st, to issue that decision in that case. I said I would guess they would do it early afternoon, maybe 2:30 in the afternoon. They actually issued their decision about 10:30 in the morning, so I was off by about 4 hours, but not too bad. I also had suggested to you, based on the oral argument I heard that first Tuesday of August, that the Court of Appeals was going to rule in favor of the governor because two of the judges on that panel were asking questions that made it pretty clear they thought, I'll just say that they thought the governor's arguments had a lot of merit. And and I don't have the names in front of me right now, but the male judge on that panel, his line of questioning was extremely on point, and he just asked a lot of really great questions, which showed that he understood some of the main aspects of the Constitution better. So I figured it was going to be a 2-1 decision, and in fact it was. So the Court of Appeals ruled in favor of the governor 2-1, essentially, on those points. I don't agree with everything in the dissenting opinion, though. The main point that she shouldn't have won, that it should have been the legislature that prevailed, I do agree with, but there are some details, especially I want to say towards the latter part of his opinion, that I think he's not quite a constitutionalist, and our entire system of government literally is dependent upon our state and U.S. constitutions. Without that, there is no authority for the government to do anything. I don't care how important they think it is. They can't just invent a power where one does not exist and where one has not been granted to them specifically, enumerated, and given to them in the state or federal constitutions. Sorry, guys. Hey, Emma, can you let her in, please? The person at the door. Can you tell her Mommy's going to be with her? Can you show her downstairs? I'm doing a Facebook Live video right now, so that's okay. I'm finishing up, but I'll be downstairs in just a minute. Okay. So I have a new volunteer here, so I'm excited about that to help us validate some signatures. But time has escaped me today. So I don't remember what line of thought I was having on that point, other than kind of explaining to you what had happened to this point. My next best guess was that with the Court of Appeals coming down with a decision last Friday, I was thinking that by late Monday, early Tuesday, Attorney Michael Williams would have filed his application for leave to appeal to the Michigan Supreme Court. And that actually didn't happen. And I called the court a couple of times and wondering if I just somehow missed it. I received an email this morning. So that was actually filed by Attorney Michael Williams at 11:10 a.m. So right before he filed his motion in the other case, he did file an application for leave to appeal to the Michigan Supreme Court in the legislature's lawsuit against the governor. So that has been filed. The brief here, oh shoot, I didn't go back and get, yeah, there's an appendix as well. The brief itself is 60 pages, and I'm not sure if I can click out of the video. Hopefully the video is still going. The appendix, oh, that's not terribly bad. Okay, the appendix is 132 pages. I was honestly thinking the appendix would be like 600 pages at this point because they have to put so much of the procedural history in there that it just continues to grow. So at any rate, the brief filed by him is 60 pages. The appendix is 132 pages. Again, those documents are now actually available on the front page, the main page of the Michigan Supreme Court's website. So the motion itself, where he is, he filed the brief, but then he also filed a motion for expedited consideration. So he wants to have the court decide to take on this appeal as quickly as possible, which he should anyway. I totally agree with that. But he's noting in here, I read this earlier, I swear he said in here that the hearing, I think he notes anyway, yeah, he does note that the court is already going to consider these issues in some form in the certified questions matter pending before it. So the other case that we've been talking about, he's referencing that other case and saying that these, in at least to a certain degree, are the same issues. So he's asking that we go ahead and you know, handle his brief and his questions now as well. And so he says, by expediting consideration of this application, what he just filed today with the court could hear from the legislature while it hears from the other stakeholders in this dispute. So again, we have plaintiffs that are these doctors' offices and this patient. The governor is already in that lawsuit, and the attorney general is already in that lawsuit, and the Michigan Department of Health and Human Services. So there's already some stakeholders involved that are in that lawsuit who are already going to be heard from. So what he's saying is that the legislature really should have a seat at the table at this as well. And they were invited to file an amicus brief in that case. That's the one I said I just didn't see that brief being filed, but I may have missed it somehow. But he says that the legislature is ready, willing, and able to respond to any further briefing schedule that the court might wish to enter and argue the case at any time the court might wish to hear it. So I think is what he's saying is, he could submit any brief at any day. If they want him to submit any other kind of brief, he'll do it. And that he's ready to argue the case at any day. If they're ready to go September 2nd, great. September 9th, great. Whatever. September 16th or whatever day that they are choosing, he's ready to do it. He's ready to proceed. So it's not going to be an issue of allowing him to proceed would somehow be a delay for the court proceedings. He's not trying to delay anything here. I want to underscore that point because a lot of people have been concerned thinking that the Supreme Court is dragging their feet unnecessarily. And in a lot of respects, I agree, because they should have agreed to take on the case when they came out with their order on June 4th. But at this point, I don't believe that's what's happening. So anyway, he also says that given the extensive briefing and argument that has already taken place, the legislature expects that the governor could say the same. Again, the governor is already a named party in the other case. So the governor doesn't even need to be brought in as an amicus. The governor is a true party to that case. So the governor already has briefing and whatnot done on that case. The governor already has oral argument time established and ready to go. They have 20 minutes to argue on September 9th, and that's already set. So anyway, he's kind of tying in different things. And no, I have not read his entire brief yet of 60 pages, nor have I read the 132-page appendix. I did read the motions here. I did read, well, there's 5 motions that I printed out, and then, of course, the application, which is essentially, it's a big brief. I mean, the number of court cases that he references at this point, this has just grown and grown and grown, right? So the number of court cases he references is not on one piece of paper or 2 pieces or 3 pieces or 4 or 5 or 6, but nearly 7 full sheets of paper just telling you which cases he's referencing throughout. And then, of course, he has all of the other authorities, the statutes and the constitutional provisions and various Black's Law Dictionary things and court rules. So, well, one court rule. Anyway, so there's a lot here. This is on my website. It's also on the Supreme Court's front page of their website, so you can find this. This is the application. It's basically a brief. The motion where he's asking for immediate consideration of that brief or that application is also on my website, and it's also on the front page of the Supreme Court's website. These other documents are not on my website, and they're last I saw, they were not on the front page of the Supreme Court's website, but they may be added. And so that is the motion that he wrote in the other case, the doctor's case, to participate in oral argument, to have expanded time for oral argument, and to have the court decide very quickly to allow him to have that oral argument time. And then the same being filed by the Michigan House Democratic leader, Christine Gregg, and the House Democratic Caucus. So their motion to be heard at the oral argument time on September 9th, the same one that I will be arguing at, as well as their motion to have the court decide very quickly to allow them to participate in the other lawsuit. So that is, I feel like I'm missing a huge piece of that, but that is what's happening at this point. The court hasn't issued an opinion on that, or an order, I should say, on that. I expect that would probably come, really, it might even come this afternoon. But otherwise, I think it would come on Monday. And I do think that I also have seen some additional amicus briefs come in on not the legislature's lawsuit, but the other lawsuit, the lawsuit with the doctor's offices suing the governor. So I have not seen any of them ask for oral argument time, nor does it appear that they would be set up for that kind of a thing. But that's just to the best of my knowledge at this point. So things are changing quite rapidly, and I definitely could be missing something. I have 114 new emails in my inbox right now, so I might have missed something. But that is doing my best to get the information to you right away. And obviously I just did an update yesterday. So now, now things are already changing. So I'm going to look real quick just to see if there are any questions that I can deal with. Really need to see my chiropractor. If you really need a good chiropractor, by the way, Dr. Chris Hawkins at West Michigan Chiropractic. I believe the address is technically in Rockford, but it's on Belding Road, essentially between Belding and the Beltline. He is an amazing chiropractor, and I have degenerative disc disease and arthritis, and I've had disc spurring and disc herniation and all kinds of other things throughout the years, and he has been an amazing chiropractor to help me through all that. So I don't get to see him very often anymore because he's about an hour away. I'm not going to comment on that because I don't think I gave that much detail, and I'm not sure if that information is accurate. So I'm just going to leave that one alone. Let's see. If you are medically unable to leave your house because you broke some bones and you would like to sign our petition, please know, number one, we're going to collect signatures into November. But number two, depending on where you live, I can almost guarantee you that we would have someone willing to bring a petition out to you to sign. We have some really dedicated volunteers. So just check our website, check for the signing locations, the signing events, the list of captains. Reach out. There's definitely a way we can get a petition to you. Oh, and Lori was already on it. So great job, Lori. Oh, no. She has not been a lawbreaker since April 30th. She's been breaking laws and our constitutionally protected rights long before that. But that's where I really started to emphasize for people and be more vocal. Hey, at least at this point, no one can argue that she's not breaking the law. But apparently people have been trying to argue that. Okay. Let's see. Thank you for the support, guys. Again, just checking to see. Okay, so Amicus, Amicus, Amicus Brief, Amicus Attorney, Amicus Curiae. So Amicus is basically when I come into this case and argue as an Amicus Attorney, I am arguing as essentially a friend of the court, not friend of the court like custody friend of the court like we have in Michigan, which by the way does not exist in other states, but a friend of the court, meaning I am there to just simply provide a different perspective on the same issues, or a historical perspective that they hadn't otherwise encountered, or a different way to hear the legal arguments presented on the same issues. I'm not raising entirely new issues. I'm just bringing the argument to them in a way that they haven't quite seen or heard it yet. And so that is what the job of an amicus attorney or amicus brief, amicus party, that is what the job is. Typically, an amicus brief is filed on behalf of an amicus party. So an official party, such as the last one I filed on a totally unrelated case to this was I filed on behalf of a group of physicians and other professionals, Physicians for Informed Consent. And so that was the named amicus party, and I was simply the attorney representing or on behalf of the amicus party. In this case, I don't officially represent in either of these two cases that I have filed. I don't officially represent either, any party. I'm not representing any of the parties to the case, certainly. But even as an amicus attorney, I don't have an amicus party. Essentially, what I've asked is to be the unofficial spokesperson for the people of the state of Michigan and the unofficial representative of the state and federal constitutions, because we have not had people there, attorneys there, advocating for their strict adherence, which is required by those of us who have taken an oath of office. So that's who I'm representing in a nutshell. So yes, no one has paid me to file those. I paid for the court filing fee. My firm paid for that, which is why I really do appreciate when people do go to restorefreedomkh.com and submit donations that way. You can donate to the petition costs for the Restore Freedom Initiative Constitutional Amendment petition. There's a separate button with separate accounts to donate to my law firm for this work, for doing this, for printing the hundreds of pages that I'll be printing today. We've had to put new drums and new toners, and I hope I don't have to replace that thing. I've had to get a new computer for this work. My other one could not keep up with all the things I had to have open at once. Anyway, so if anyone does want to donate to those kinds of things, the court costs when I have to file these briefs, the Supreme Court, I want to say, is $75, but there's an electronic filing credit card fee, so it ends up being like $77.25 or something like that. And then the Court of Appeals, I want to say that one was 100 or 150 or 175. Anyway, it was more than the Supreme Court, which I thought was strange, for filing fees. So I've been paying those every time that I've done that. I did have Mike Detmer for Congress over in the 11th Congressional District, who paid the first time around for a whole bunch of stuff for me to be able to file. That was greatly appreciated. Okay, so let me just make sure that there are no I am located in Hudsonville, and if you have seen our petition, the Restore Freedom Initiative petition, at the bottom, the address for the Restore Freedom Initiative is printed right on there, and that is actually where we are, 7194 Michael Drive in Hudsonville. We would absolutely love to have you as a volunteer, and that would be great. There's actually a volunteer forum on our website, restorefreedomkh.com. Restore Freedom K as in Catherine, H as in Henry.com. And get involved is one of the tabs, and you can sign up to be a volunteer that way. And we will be simplifying the format of that page very soon. I have two very adamant volunteers that we need to do some updating. We had revamped it about a month and a half ago, but they'd like to simplify it again and find a good balance there. But anyway, you could still sign up nonetheless as a volunteer to help us with that. Okay. Oh, my goodness. Okay. I will have to, I guess, Kristen, Megan, you're being a little naughty that you get disabled, but you must have been advocating the truth a little too zealously, I guess. So I'm glad that you mentioned that. Okay. I think I have answered these. Wait. Should the Supreme Court rule against the governor? Is the state open? And okay, so the question is, should the Supreme Court, if the Supreme Court rules against the governor, so on September 9th, after oral arguments, whenever they actually issue their decision, let's say it's the next week. I have no idea when it would be, but let's say September 16th, they come out with a decision and they say that it is in fact a violation of state law and as well as the Constitution to issue these executive orders. If they say that, then even though that decision comes out in terms of another case that then is going back to a district court, a federal district court judge, yeah, I would say the executive orders are no longer in effect because quite frankly, the executive orders have no legal effect right now. They are not legally binding at all. No executive order in the state of Michigan is allowed to control the people and be used as a weapon or a tool or in a replica of a state law with any kind of penalties against the people. That's not what is allowed. The state constitution is very clear. Article 5, Section 2 of the state constitution says that the governor can issue executive orders that serve to reorganize the executive branch. And even when she does so, she has to submit those executive orders to the legislature. They have either the 60 or 90 days that I can never remember to disapprove of that executive order if they choose to do so. And if they choose to disapprove of it, then they disapprove of it and she doesn't get to have the change that she wants. During these executive orders of 2020, last I saw, she was up to 172. Of the 172, there are 9, I believe, that are related to executive branch reorganization. Other than that, they're all COVID related, where she's essentially trying to create laws. She can't do that. So, yes, to answer Michelle Burke, the he I was referring to who is ready to argue the legislature case, I do believe that is Michael Williams. I can't keep flipping back and forth between screens to see if he was the person that actually filed that particular document, but I do believe that is who is saying he's ready to argue on behalf of the legislature. So let's not, I can't underscore this enough. So if the Supreme Court decides against her, are the executive orders eliminated? The executive orders, the governor can always sit there and try to write these executive orders to control us, but they are not legally enforceable. They're not going to be any more legally enforceable if the Supreme Court says they are legally enforceable, because they're not legal. They're not constitutional. They clearly violate state law. They clearly violate the Constitution, both the US and the Michigan constitutions. And I, for one, am not going to stop fighting until the rest of our government realizes how to follow the government parameters, the governor's, the restrictions placed upon the governor, the legislature, and the courts in the constitutions. The only way those three branches of government have any powers whatsoever is because they are given to them either in the state or federal constitutions. That is our contract with each other. That's how we live together in society, where we say we are going to allow the government to control us in certain ways so that we can have protections from certain things, but that contract only goes so far. We have in Contract Law 101 the Four Corners Rule, the parole evidence rule. Insofar as you have a contract that is in writing and purports to contain the whole agreement of the parties, you can't go looking at extraneous information. You can't go looking to what's happening in 2020 with the coronavirus if the contract written in 1776 or in the state's constitution, 1963, if those constitutions, if those contracts are written and clearly describe the entire agreement between the parties, the people, and the government, then you can't go looking to extraneous stuff to try to describe it as something different than what it is. That's the whole point. So no, I don't care what the court says. Quite honestly, to a certain degree, it does not matter what the court says. We have these rights that are given to us by God. They are guaranteed to us in our U.S. and our state constitutions. And it's the job of every single person who has taken an oath of office under Article 11, Section 1 of our state constitution, or Article 6 of our U.S. Constitution, to uphold their oath of office, to uphold these state and federal constitutions, and do their job, whether they like them or not, whether they think coronavirus is scary or not. That's not the point. Those are totally irrelevant points. What matters is the contract that we have. And that contract is binding, period. And our state and federal governments have trampled all over that and reworked it and rewritten it and reworded it for far too many years. And it's time we stand up as a people and said, enough. Whether you like it or not, you got to follow it. In fact, there's parts in there that I don't like, the parts that have been added in, the parts that have convoluted and complicated this whole thing. And that's why I wrote a constitutional amendment, because that's how you change it. You don't just not follow it because you don't like it. You change what you don't like. You go out there and you write a constitutional amendment as an individual person, and you try to get thousands of people out there that agree with your position to the point that you can get the required number of signatures in the required amount of time, and then you can put it on the ballot and have the people vote in favor of that by a simple majority, and then within 45 days after that vote has taken place, that becomes part of the state constitution. That is exactly what you need to do if you don't agree with something that is in the Constitution. You don't just ignore it or change it or modify it as to how you see fit on your own. I don't care what office you're in. You have to follow the Constitution. So anyway, simple little innocent question that led to me getting all fired up about that. Sorry. Yes, I'm on PayPal. Those links are on our website. Sorry, that's my old website. RestoreFreedomKH.com, and you can go to shop and donate. You can find all of our products that we have available for Restore Freedom gear. More freedom, less government is the basic saying or slogan on there. And none of those products give us money. Those are not money makers for us. That is just to get the word out and to get people engaged and have something tangible at cost. We don't get money off that. The donate button is where you can donate funds if you would like us to have additional funds to be able to do other things with. Okay. She's getting away with it because people are ignoring their constitutional obligations. And we need to step up, hold our individual office holders accountable. Your city clerks, your county clerks, your county commissioners, your city council members, your school board representatives, your principals, your public school teachers. Any government employee has the duty to uphold the Constitution. Every single government officer has the duty to uphold the U.S. and Michigan constitutions. I don't care how small of an office it may seem. I don't care how big it is. There's no exceptions. Every one of them has a duty to uphold the state and federal constitutions. So we need, as a people, to hold them accountable and remind them of that. No more excuses. Our state reps have been nothing but excuses from day one on this. And then when they don't like getting called out for doing stuff and writing bills that are craptastic and violate our rights even further, then what do? Oh, they start calling me the woman with the video, or, hey, you know, that person that's writing all these things or saying all these things, you know, look at their credentials, because, you know, I heard that their credentials aren't that great. You know what? I could be a garbage truck driver. That's okay, because I'm an American citizen, and the Constitution applies to me the same as it does to any other United States citizen. So whether I have the credentials or not doesn't really matter. My credential is that I was born here in the United States, and the contract that is called the U.S. and the Michigan Constitutions, those apply to me. And no state rep should be all high and mighty because they were elected. Nothing makes you better than anybody else. Nothing. We're all given special gifts and talents and abilities from God, and we're all equal in his eyes. So you need to take yourself off your little high horse there and not act like you're any better than anybody else. No one is above the law and above the Constitution. The Constitution is the contract that everybody here in the United States has to live by. If you don't like it, leave. Or try to change it. But not illegally. Change it the way that the Constitution requires that you change it. But if anybody is wondering what my qualifications are, I am an attorney. I have been doing mediation and dispute resolution work for, oh my gosh, 14 or 15 years. And restorative justice and child protection mediations and adult guardianship mediations and divorce mediations, car accident, you know, so auto, the no-fault insurance mediations, general business disputes and contracts, and landlord-tenant, and civil rights, and agriculture and rural development, you name it, okay? I've also done general practice work for quite some time, and I have, I first was licensed to practice law in the state of Minnesota because, well, that's where I went to law school and that's where I took the bar. And yes, I did pass it on the first try, and I did score high enough on the, oh gosh, it's so long ago, I don't remember now which one's which. I did score high enough on the essay portion that they didn't grade my multi-state. I think that's how that goes, which is the multiple choice. And then when I moved to Michigan, I had to take the Michigan State Bar all over again, or for the first time, I should say, but I had to take a different state bar. And yes, I passed that one on the first try. And I did score high enough on that, that had I taken both pieces here, I wouldn't have even had to have the other half of my test graded, because that's how they do it. But because I was coming in from another state, they made me go ahead and have that second half of the test. So I've been licensed to practice law in the state of Michigan ever since, which was 12 or 13 years ago. And then I got licensed to practice, or admitted to practice, in the Federal District Court, Eastern District of Michigan. Then after that, it was the Saginaw-Chippewa Tribal Court in Mount Pleasant. It's their own entity, their own country. It's not anything related to the laws and constitutional provisions that we've been talking about here in these videos. After that, I did get licensed or admitted to practice in the Federal District Court for the Western District of Michigan. And then after that, it was the United States Supreme Court. So, and I do have some briefs that we've filed as recently as this year, I believe, in the United States Supreme Court. So those are my credentials in a nutshell. I've taken, I don't know, 450 hours of continuing legal education coursework since I graduated from law school, even though Michigan doesn't require any of attorneys, which is really weird because I think we're the only state that doesn't require continuing ed, but whatever. And I could answer any other questions about that, but that'd be another video for another day. So, okay. I am glossing over this. I apologize because I have to get to some other things and I don't want to waste too much of your time, but I am trying to see if there is. Oh, let's see. I can't be that old. I don't know. What did I say that says I'm old? The thing that really makes me feel old is that I said I used some sort of beauty product for the last 25 years, and then I had to stop and think about that. That's horrible. I do have a college sophomore for a child, and 2 high school seniors, and a first grader. So that kind of makes me feel old, but having the first grader makes it all better. Um, Yeah, so this is the last question I'll answer real quick. Business owners could choose to not comply, could they not? Yes. Now, does that mean it's going to come without logistical consequences? No, they've made it pretty clear that they're going to utilize every single other kind of statute. That's why repealing the 1945 Act is not going to solve all of our problems. The 1976 Act is still there, and there's a ton in there she hasn't even started to use yet. If you think the 1976 Act is out of the picture for COVID-19 because she already used the 128 days plus the one extension, there's stuff in there she hasn't even begun to tap into. So no, that one should be gone too, but they don't want to get rid of that one too. I don't know why, other than it gives the legislature a bunch of power over us as well. Both of them have an immense unconstitutional amount of power over us by utilizing the 1976 law. But not only, she's not just using those two, she's using the public health code and a whole bunch of other things that are out there. And so she's relying on being able to order different local health departments and other things to come down on local businesses and try to find, give them violations and fine them that way, bringing the misdemeanor charges for other things. And so she's trying to get this end, around game where she's fining all these people and doing all these things to people that she simply should not be doing. So in the end, yes, the legal right of a business to say, I am not going to enforce this executive order, they have the legal right. But as a very intelligent, good Christian man who is a business owner in Traverse City pointed out to me, oh my gosh, when was it that I went up there? I want to say the first week of May, to explain to the business owners how they have the legal right to be open and do all this stuff. And the executive orders aren't even a legal thing anymore, let alone constitutional. He pointed out that there's some logistical concerns because if you have your license pulled, then a lot of vendors won't sell to you, or you'll have an issue with other not chain of command, the chain of the products, right? Your products and services. If you're a restaurant and you have a certain provider that gives you your beef or your poultry, and then you have another place that you get your vegetables from, and then you have another place, Pepsi or Coke, that you get your pop from, or whatever, right? You have all these different. You have another company that might provide all of your product, your paper products, the to-go bags or napkins or whatever. If one of those all of a sudden says, nope, I'm not comfortable doing business with you because you don't have such and such a license, or the health department is after you or got a spotlight on you. No, I'm not doing business with you. What would that business owner do? That's where there's a struggle. And I understand that. The problem is with more and more business owners standing up and doing the right thing, then we can try to all work together and get this done without them. But it does take a lot of people willing to risk, quite frankly, everything in order to get to that point. So, at any rate, and that's what sounds like the Frisky farm market has done up in the Traverse City area. I haven't seen the recent information. I haven't really talked to them directly since I was up there talking to them on July 3rd on my birthday. So they bought me dinner, and that was really nice. And it was nice to see the place there and buy some good things and some dill pickle popcorn seasoning. That was actually really delicious. Mike, if you're watching this, could you bring some popcorn home with you from the grocery store? Anyway, but they have filed a lawsuit against the governor. I believe they did file in federal court. And I believe they went with the same attorney that is representing Carl Mankeet, the barber. So at any rate, it does take businesses willing to step up and step out and be willing to risk some of those things. But even they had severe, logistical concerns. And so that is what we're left with. Legally speaking, you have every right as a business owner to say, I am not going to post some stupid sign on my door about the COVID-19 executive orders because they are not constitutional. And I will definitely support you every step of the way on that. I can't guarantee that I'm going to be able to be personally available to walk you through whatever court proceedings would be necessary to make sure that your rights to life, liberty, or property are not inappropriately stolen from you by the government, though. That's the hard part, right? So please get out there and support those businesses that are doing the right thing and that are not trying to enforce this mask stuff upon their customers, or that are doing whatever they can to help people and to follow the Constitution as it's written, that contract that binds us all as a community in the first place. Do what you can to support those businesses. Do what you can to not have anything to do with those other businesses that are adamant to support these illegal and unconstitutional executive orders. That's fine. Trader Joe's might, but I have a feeling Trader Joe's is also one of those places that is really, practicing for 15 years. Oh, that's what I said. Well, I started working in the legal field, 19 years ago. That was working in my very first law firm. And those were the days in Slayton, Minnesota. So I've come a little ways since then, I'd like to think. But at any rate, Trader Joe's might have some good dill pickle popcorn. However, I would much rather spend a little bit more money and get a really great product from a really great local business, which is Frisky Farm Market up in the Traverse City area. So anything that you can buy from a place like that, please do. Please do. In fact, I want to say today or tomorrow, I don't know if Frisky has anything to do with it, but in general, in the Traverse City area, there's that Pence thing going on, but there's also a Stand Up Michigan event. Sounds like there's going to be a lot of people up there. I would ask if any of you are willing to go up there to circulate the constitutional amendment petition. That would be fabulous. But while you are up there, please make sure to see Dave Sears over at the Fresh Coast Market. The most phenomenal pizza and salads, and I had a sandwich or a panini at some point. They have a seafood salad, some chicken wings. I mean, the food is phenomenal. The desserts look so fantastic. I think I gained 10 pounds just looking through the little glass there. But he is a definite freedom fighter who is having that struggle to make sure he is keeping his business alive while he is respecting people's freedoms. Great guy, though. Great business, great food, great prices. So that is Dave Sears over at the Fresh Coast Market in Traverse City, and the whole Frisky family at the Frisky Farm Market. Please make sure that you stop and get some great food from both of them and enjoy the other products they have as well. So with that being said, this has been a long enough presentation of court updates that diverted into a whole bunch of other topics. Thank you so much. I believe I answered everybody's questions, but please stay engaged, stay informed. And oh, our pocket constitutions came in. So we will have those available to you at cost through our online store as well. That's through the Square store. We did have one piece that we're waiting for to come in, but I think we'll be ready to start shipping those out pretty darn soon. So if you want to start placing those orders, we should have that up as a product on that Square store later tonight or tomorrow, hopefully at the latest. In fact, I'm going to make myself a note that we need to pocket constitutions for Square. But anyway, it might be maybe about $2, I think, to be able to have those by the time, you know, we have the cost of the Constitution and then getting them back out to you. That'll include the shipping and everything like that. And we should be able to get them to you as well as quickly as the U.S. mail goes. So anyway, though, I've been the one that's personally addressing and stamping and whatnot, all of the orders that are coming through our online store. There's a separate online store where we don't see the orders and don't handle the products. That's for the t-shirts and most of the yard signs and things like that. But all of the bumper stickers and the window decals and the calendar magnets and the pocket constitutions and whatnot, that'll all be that's so far done by me. So as you can see, I'm a little busy these days, but I want to make sure we get stuff out to you at cost, make it affordable. This has been a very tough year for everybody, and we want to make sure that you guys can have every possible opportunity to share the word about freedom and what it means and what we can each do to fight for it. So please make sure you tune in on September 9th at 9:30. If you only have 5 minutes to listen, at this rate, it does look like at about 10 o'clock, I will be the one arguing at 10 o'clock. Of course, I can't guarantee that, but September 9th, around 10 o'clock, Attorney Catherine Henry, should be arguing on behalf of the Constitution and the people of the state of Michigan. So thank you so much for tuning in, and I hope you all have a very wonderful weekend.